Alright, so we're going to start with the third objection that I'm going to review. And this objection is known as character evidence. So this is another very nuanced rule of evidence, and it's there are quite a lot of things to remember about it and a lot of uses for character evidence. But I think once you sort of understand why character evidence, or what character evidence's role in a trial, you'll be able to understand how it's used and why it's used. So, just to start out, character evidence is commonly referred to as propensity evidence. So, a person can have the propensity, which is sort of the likelihood, to act violently, drive drunk, or expose themselves in public. And such character traits have the potential of prejudicing the members of the jury. This is why the general rule regarding character evidence is as follows, and I quote, "Evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith." And I put these four words here because they're very important in how you understand character evidence. So essentially, action in conformity therewith is referring to if I, do something, right? The likelihood that I do it again later um, is greater if I have done it before. And sort of you're trying to prove that these actions are part of a person's character. So, in other words, generally speaking, a person's past conduct cannot be used to prove their present conduct. And the rationale for this general rule is that if a person's past is exposed for the jury to see, the jury is naturally going to think, once a criminal, always a criminal. And the primary concern is to shield the jury from knowing everything about the witness's past. This way, it is more likely that jurors will give the witness a fair shake and not hold the witness's past against them. And there are exceptions to this general rule that I'll discuss below. So here's sort of an example to just illustrate the general rule of character evidence. So let's say Richard is being accused of domestic violence. The prosecutor introduces 5 previous convictions for the same offense. Richard's attorney will object to improper character evidence, and that's the objection that you use, because the prosecutor cannot bring in Richard's prior convictions for domestic violence to show that he is guilty in this case. Alright, so let's go over the methods of proving character. So there are 3 acceptable ways of demonstrating a witness's character trait. 1. Reputation. So reputation, this method is used mostly on direct examination, but it can be used on cross-examination as well. Assuming adequate foundation is laid, that the witness knows the subject, has known them for a long time, etc., that person can testify to the reputation of another person. Even if this reputation was learned about through hearsay, the testimony is still admissible pursuant to the reputation in the community exception. Alright, the next one is opinion. So this method is used mostly on direct examination, but again, it can also be used on cross-examination. Assuming adequate foundation is laid, a witness may give their opinion as to the character of another person. That one's fairly straightforward. And lastly, specific instances of conduct. Generally, this is only allowed on cross-examination, so I'll put an X there for cross. It is often used as a means of challenging the reputation or opinion testimony given on direct. Alright, so now that we've gone through that, let's talk about prior acts inadmissible for limited purposes. So let's go back to the general rule. Character evidence is not allowed for the purpose of showing action in conformity therewith. However, there are other purposes for which character evidence is admissible. So, you need to make it clear that you are not offering the character evidence for the purpose of proving action in conformity therewith. Rather, you are offering it for another purpose. Alright, so this one we'll just go through step by step. So now remember that for some pieces of evidence there may be more than one acceptable purpose under which the evidence may be admitted. And if you believe that there are multiple acceptable purposes, cite all of them and briefly explain why each is applicable. And that way, if the judge doesn't buy, say, your motive argument, he may buy your intent argument. So here are the following acceptable purposes. So, motive. Say the defendant is charged with embezzlement. Evidence that the defendant was found liable and owes money to a prior personal injury plaintiff would be admissible to establish that the defendant has financial motive to embezzle. Opportunity. Suppose the defendant is charged with robbing a grocery store on a Friday night. Evidence that the defendant regularly drives by the local grocery store on Friday nights could be used to show that he had the opportunity to commit the robbery. Intent. Suppose the defendant is charged with sexual assault. He claims that he believed the woman consented. The prosecutor would likely be allowed to admit prior sexual assault convictions to prove that the defendant had the requisite intent. Preparation. Suppose the defendant is charged with trafficking cocaine. The prosecutor would be allowed to admit evidence that 2 weeks before the defendant was arrested, he was observed with weights, measures, and marked plastic bags as evidence that he was preparing to package the cocaine for trafficking. Identity. Suppose a serial killer, let's call him the Joker, leaves a Joker playing card on the dead bodies of all his victims. When the police arrest Jack Napier to find thousands of Joker cards in his office, this evidence is likely going to be admitted into evidence to prove identity. So when criminals routinely leave a calling card in past instances, it is typically admissible to prove identity in the current case. Knowledge. So this one is essentially the knowledge that a crime was committed. Common plan. This one is also similar to the cocaine example. To establish a common scheme or plan for trafficking cocaine in that instance. Absence of mistake or accident. Suppose the defendant is arrested for receiving child pornography in the mail. He may argue that he never ordered it and it was sent to him by accident. However, the prosecutor would likely be able to admit evidence that the defendant had placed orders in the past to prove that it was no mistake on this occasion. So those cover the limited purposes for which prior acts are admissible. Now, the last thing we're going to deal with character evidence is habit. So habit is admissible in court, and while character evidence is generally inadmissible to prove propensity, evidence of habit is admissible. The difference being that habits are regular, if not invariable. Examples of habits include, say, brushing one's teeth every evening before going to bed, locking one's car after closing the door, or washing one's hands before dinner. And in order to prove the existence of a habit, there must be a large enough sample to establish a pattern of behavior and a sufficient uniformity of response. If the sample size is too small, or if the response is not uniform, a habit is not established. So that concludes our discussion on character evidence and the objections that apply to it. So in our next video, we will be discussing lay and expert opinions. Thank you.